McKenzie Sharillo was just handed another loss. The Ohio Supreme Court declined to hear her appeal of her murder convictions. We're going to try to get to the bottom of why this happened and what it means for her, because she may now be looking at spending the rest of her life behind bars. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber.
The Ohio Supreme Court order is 4 lines long. 4 lines. That is the entire official response to a woman who says she will die in prison if that document stands. The order reads, upon consideration of the jurisdictional memoranda filed in this case, the court declines to accept jurisdiction of the appeal pursuant to Rule 7.084. No explanation, no analysis, no acknowledgement of the constitutional arguments her attorneys spent months constructing. Just a stamp. A signature, a door closing. Think about what that actually looks like. You are serving 15 years to life. You have filed every motion available to you. You have argued your constitutional rights were violated. You have argued your lawyers failed you. And the highest court in Ohio reads your brief, considers your arguments, and responds with 4 lines and a rule number.
Interesting part I want to get into. And it's not like the Supreme Court here gave a full, multi-page written explanation. No, rather, there was an order that was signed by Chief Justice Sharon Kennedy that stated, quote, upon consideration of the jurisdictional memoranda filed in this case, the court declines to accept jurisdiction of the appeal pursuant to Rule 7.08.
That is not a ruling on the merits. That is a refusal to engage. And the difference between those two things could cost McKenzie Sharillo the rest of her life. Before we go deeper into what the records actually show, make sure you are subscribed to The Darkest Crimes, because we do not just cover the story, we follow the evidence. Hit the bell so you do not miss what comes next. Now, back to the record. McKenzie Sharillo was 17 years old on July 31st, 2022. That day, a car she was driving entered a building at a speed documented by the vehicle's own data recorder at over 95 miles per hour in a 35 mile per hour zone. 2 people inside that car did not survive. Her boyfriend, Dominic Russo, his friend, DaVon Flanigan, both dead. Sharillo survived. She was charged, tried before a judge.
% off. Yep, more bad news for convicted murderer McKenzie Sharillo. The Supreme Court of Ohio has refused to hear her appeal once again. I'm going to talk about why I say once again. Remember, she drove a car 100 miles per hour into a building, killing the 2 passengers, her boyfriend Dominic Russo and his friend DaVon Flanigan, back on July 31st, 2022. She was found guilty by a judge in a bench trial. Remember, this wasn't in front of a jury. It was in front of a judge. She opted for that in front of a bench trial. She was found guilty of 4 counts of murder, 4 counts of felonious assault, 2 counts of aggravated vehicular homicide, 1 count of drug possession, and 1 count of possessing criminal tools. But what has happened now is that she tried to appeal those convictions, and the Supreme Court said no.
She was sentenced to 2 concurrent terms of 15 years to life. She will not be eligible for parole until 2037. That is the official record. That is what the state of Ohio says happened. And Sharillo has been fighting that record from the moment the verdict came down. Her defense has always centered on one claim. She blacked out. She has no memory of the crash or the minutes leading up to it.
Sharillo has insisted that ever since the beginning, she has no memory whatsoever of the crash or the minutes leading up to it, that she and her family have suggested that she has a diagnosis of POTS, a medical condition that can cause dizziness and fainting.
She and her family point to a diagnosed medical condition called POTS, postural orthostatic tachycardia syndrome, a condition that can cause dizziness, loss of blood pressure regulation, and in serious cases, loss of consciousness. Her mother testified at trial that Sharillo had been diagnosed with POTS in 2017 at the Cleveland Clinic. Her mother also testified that Sharillo had experienced a POTS episode just 1 or 2 weeks before the crash, that it had been, in her mother's words, really bad, and that she had not taken Sharillo to a doctor or restricted her driving afterward.
The POTS episode a week or two before the crash and reported that it was really bad and it hadn't been that bad in a long time and she was scared it was going to get worse. Natalie admitted that she did not take Sharillo to a doctor or limit Sharillo's driving privileges. Well, Dr. Sang testified that it's possible that Sharillo could have suffered a medical emergency like a seizure or mini stroke while still appearing normal in the medical examination. Other evidence makes this potential explanation seem
Here is where the record gets complicated. No official medical expert testified at trial on Sharillo's behalf about POTS. No specialist. No formal diagnosis submitted into evidence. Her mother's testimony was the primary documentation of the condition. The prosecution, on the other hand, pointed to the vehicle's data recorder showing the accelerator pedal was 100% depressed the entire time. No brakes applied, not once. And critically, the evidence showed someone manually moved the gear shift back into drive after it had been moved to neutral in the seconds before the crash. The prosecution argued, and the trial court agreed, that no medical condition can explain simultaneously losing the ability to brake while also intentionally manipulating the gear shift. That is the wall Sharillo's medical defense has always run into. One action, the gear shift, requires intentional, conscious movement. The other action, pressing the accelerator and never touching the brakes, was sustained and uninterrupted. Those two facts do not coexist easily with a blackout explanation. And yet, the question this case keeps circling is not whether she was guilty. A judge already decided that. The question is whether she received the defense she was constitutionally entitled to. And that question has never been properly answered. She could die in prison. That phrase is not commentary. That is the actual argument her attorneys submitted in writing to the Ohio Supreme Court. Her most recent appeal rested on what lawyers call ineffective assistance of counsel. The Sixth Amendment guarantees
Back now to Sharillo's brief to the Supreme Court, because basically this is the argument that she makes. I had bad lawyers. Ineffective assistance of counsel. It's the Sixth Amendment, right? Now, this is where it gets a little procedural, it gets a little specific, but this is the main theme here, and it's important. The main issue about taking this to the Supreme Court is about whether or not she is bringing this post-conviction.
Sharillo's team argued that her trial attorneys knew about the POTS condition, knew it was relevant, and failed to adequately investigate it, failed to bring in expert medical testimony, and failed to make it a real part of her defense.
Okay, and let me start with the opening paragraph of her brief. It says, quote, McKenzie Sharillo, who was 17 years old when the car she was driving crashed into a wall at a speed in excess of 80 miles per hour, is serving a life sentence for murdering her two passengers. There is medical evidence that McKenzie Sharillo suffered from a pre-existing medical condition that could have caused her to black out while driving. But that evidence was only cursorily referenced at trial because defense counsel, despite being aware of Ms. Sharillo's condition, did not adequately investigate this aspect of the case.
If that argument is correct, and a court were to agree with it, the legal consequence is significant. It could mean her conviction was obtained without the constitutional protections she was owed. But here is where the case took a turn that has nothing to do with guilt or innocence and everything to do with paperwork and a calendar. The mechanism for raising an ineffective assistance claim after conviction in Ohio is called a post-conviction relief petition. Under Ohio law, a defendant has 365 days from the filing of the trial transcript to submit that petition. Sharillo's legal team filed theirs on October 24, 2024. The main trial transcripts had been filed on October 23, 2023. Because 2024 was a leap year, that filing was 1 day late. 1 day.
The petition. She filed a petition on October 24th, 2024, which is the same day that many of her exhibits were notarized. Because 2024 was a leap year, Sharillo's petition was late by 1 day. The trial court properly denied her petition as untimely. Realizing the enormity of her error, Sharillo argued on appeal that the 365-day clock did not start until transcript of a probable cause hearing in the juvenile court was filed in the direct appeal on December 15th, 2020.
The trial court rejected her petition as untimely. The 8th District Court of Appeals agreed. And now, the Ohio Supreme Court has refused to even hear the argument about whether the deadline was calculated correctly. She could die in prison over one day. Her attorneys had argued that the clock should not have started on October 23, 2023, because there was a separate set of juvenile court records that were crucial to her case and were not filed until December 15, 2023. Her argument was that a trial transcript, as the law defines it, should encompass all records necessary for appellate review, not just the main trial record, and that the clock should have started when those juvenile records were finally filed.
If your attorney made a big mistake, you're out of luck. So what happened in Sharillo's case? Well, basically, Sharillo had first appealed her case in September of 2023, and her lawyer requested all the court records. The main trial court records, they were filed on October 24th, 2023. However, there was a separate, what she says, crucial record, important record, from her juvenile court hearing, and that was omitted. It had to be tracked down later. And by law, again, I said she had 365 days to file her next petition. Her new lawyers filed it on October 24th, 2024. So if the 365-day clock started when the main trial records, the trial transcript was filed, they were exactly 366 days late, so 1 day late. But she's making the argument, no.
If that interpretation had been accepted, her October 2024 filing would have been timely. The prosecution's response was precise and unambiguous. A trial transcript means the record of the proceeding in which guilt was determined.
If your attorney made a big mistake, you're out of luck. So what happened in Sharillo's case? Well, basically, Sharillo had first appealed her case in September of 2023, and her lawyer requested all the court records. The main trial court records, they were filed on October 24th, 2023. However, there was a separate, what she says, crucial record, important record, from her juvenile court hearing, and that was omitted. It had to be tracked down later. And by law, again, I said she had 365 days to file her next petition. Her new lawyers filed it on October 24th, 2024. So if the 365-day clock started when the main trial records, the trial transcript was filed, they were exactly 366 days late, so 1 day late. But she's making the argument, no.
A juvenile probable cause hearing is not a trial. The clock started when the trial transcript was filed. The rules are the rules. Now here is the ticking clock question that should not leave your mind. If McKenzie Sharillo's attorneys made a genuine legal error in calculating that deadline, and if that error means she can never formally argue that her trial lawyers failed to properly present her medical defense, does that mean two separate sets of attorneys have now failed her in sequence? And if that is true, what exactly did her Sixth Amendment right to counsel mean in practice? The Ohio Supreme Court's 4-line order does not answer that question. It does not engage with it at all. She could die in prison, and the court that had the authority to examine whether that outcome was constitutionally sound chose not to. What Sharillo said in a documentary interview broadcast on Netflix after her conviction is now part of the public record. She stated, "I have excessive amounts of remorse for Dominic, DaVon, both of their families. This was not intentional, and I will do everything I can to prove that to the world and the families."
Response was, they say, quote, "Defendant appellant McKenzie Sharillo drove her vehicle at a high rate of speed into a building, killing her boyfriend and another passenger. Her vehicle's data recorder showed that Sharillo drove more than 95 miles per hour in a 35-mile-per-hour zone with the accelerator pedal 100% depressed, never applying the brakes. Sharillo maintained control of the vehicle as it maneuvered a large curve in the road, never veering off the road. She also previously threatened to crash her vehicle while her boyfriend was inside it. Defendant appellant McKenzie Sharillo miscalendared the date that her petition for..."
That statement does not exonerate her. It does not resolve the physical evidence about the gear shift or the accelerator, but it is the statement of someone who believes, however the law has ruled, that she did not choose to do what she is serving 15 years to life for doing.
Other options, right now as at least, although I'll tell you maybe something that she can do. It looks like she might just have to serve out her 2 concurrent sentences of 15 years to life in prison. So I want to go back into the records here, and it appears that Sharillo had filed a notice of appeal to the Ohio Supreme Court earlier this year. Then in a follow-up brief, she lays out her argument.
Where this leaves her is narrow. The Ohio Supreme Court has now declined to hear her case twice, once on the question of intent and once on this post-conviction petition. Barring the emergence of newly discovered evidence that fundamentally changes the evidentiary picture, her next realistic moment before a decision-making body is a parole hearing in 2037.
As well, you heard the prosecution describe it too. It's pretty accurate about how they decided it. So look, what does it mean for Sharillo? It means she's out of options. It means unless there's some newly discovered evidence that proves she didn't do this, that proves she's completely innocent, that changes the whole game, I think her only option now is a chance at parole in 2037. Although you do wonder whether her alleged reported behavior in prison and even doing the Netflix special, is it going to hurt her chances? Discussion for another day. That's all we have.
Whether her conduct in prison and the public attention brought by the Netflix documentary help or hurt that prospect is an open question that the legal analysts following this case have not resolved. What is not an open question is this. A 17-year-old drove a car into a building at 95 miles per hour, and 2 people died. The state of Ohio convicted her and intends to keep her incarcerated for at minimum 15 years. She says she blacked out. The prosecution says the physical evidence makes that impossible. The courts have sided with the prosecution at every level, and the mechanism she was trying to use to argue that her trial lawyers never gave the blacked out theory a real evidentiary foundation has now been closed off on a technicality involving 1 day and a leap year. The Ohio Supreme Court's order declining jurisdiction in this case, signed by Chief Justice Sharon Kennedy, is part of the public record and is accessible through the Ohio Supreme Court's online case docket. The case is State of Ohio versus McKenzie Sharillo. The post-conviction petition, the prosecution's response, and the lower court decisions that led to this moment are all there, available for anyone who wants to read the full argument on both sides. Here is the question we want you to answer in the comments. If a defendant's lawyers miss a filing deadline by 1 day due to a legal calculation error, and that error permanently closes the door on a constitutional claim about trial counsel effectiveness, do you believe that outcome is consistent with the Sixth Amendment right to effective assistance of counsel? Not whether she is guilty. The court has answered that. The question is whether the system that convicted her gave her a constitutionally valid path to challenge how that conviction was obtained. Tell us what you think below. If this kind of evidence-driven case analysis is what you come here for, like this video, share it with someone following this case, subscribe to The Darkest Crimes, and turn on notifications, because this one is not over yet.